It's my honor and pleasure to be here today and to discuss the issues of human rights in Ukraine and to present to the audience some results of our work which has been done by Center for European Integration together with Westminster Foundation in Ukraine for the last 3 years. As you already heard that the Center for the European Integration joined the work of Westminster Foundation of Democracy not from the very beginning of the project, but in August of 2010. Since that moment, we were conducting trainings for the staff of the parliament. As well, we've done a lot of work with civil society organizations dealing with human rights issues in Ukraine. So you can see that the first training was conducted together with Westminster Foundation and International Bar Association, and we had the pleasure to work together with Angela Patrick on this training. And after this, we also conducted numerous trainings and had numerous meetings with committees of the parliament. Our primary counterpart within parliament was the Human Rights Committee of the parliament. We also worked with the Ombudsman office in Ukraine, but because our main goal was to deliver the message that human rights are not limited to the work of human rights committees, but it's a fundamental value which should be introduced into all legislation passed by the parliament. We worked with numerous committees. We ended up working at least with 6 committees within the parliament on permanent basis on different issues related to human rights. During this period of time, the major issues which were analyzed and discussed with the participation of Westminster Foundation for Democracy were the right to protest, right to fair trial, which includes the issues of due process, selective justice, execution of the decisions of the European Court of Human Rights, combating trafficking in persons, women and children, as George mentioned yesterday, was also one of the issues. Rights of people with disabilities. This issue was the topic for the training which we conducted for the staff of the parliament, as Ukraine recently signed and ratified UN Convention on the Right for People with Disabilities. Rights of minorities to study in own languages also was an issue that we discussed and provided our expert opinion on because it was relevant to some legislation pending through the parliament, and I'll talk about it in more details in a few minutes. Right to health protection of the prisoners was also important topic, and it remains hot topic in Ukraine, and it also was related to some processes of prosecutions of political people in Ukraine. So it's been discussed in Ukraine, and we conducted some trainings and provided feedback on the legislation and administrative practices in Ukraine. So I would like to start with the first case study, a right to protest, as it was one of the first issues that Committee on Human Rights asked us to comment on. Just for you to understand, when we started the cooperation, we were introduced to the Committee of Human Rights at the Parliament as a group of experts who will be available for them to provide feedback, to network with international group of experts. So Committee of Human Rights from the very beginning was very open for this cooperation. They said that they are willing to cooperate, and they really appreciated any comments, any advice provided by us, and especially by our international experts. So in case of right to protest, we reached to Angela and to IBA, and we conducted training together with Westminster Foundation and IBA for the staff of the Parliament, reviewing different aspects of the right to protest and limits which might be introduced to this right by the government. The draft law, as you can see on right to process, has been discussed in Ukrainian Parliament since 2008. And it was general belief in Ukraine that as constitution provides the right to protest to the public, to the people, there is no need for the law. And you probably all follow the news, and you know that Ukrainian people are very active in exercising this right, and we've had many protests, and the biggest success in execution of this right, I would say, was the Orange Revolution, when we really had a lot of people on the streets exercising this right freely. And for this, numerous human rights NGOs, they believe that there is no need for additional legislation, because by introducing legislation, government may limit this right too much. So when we were invited to join the process of legislation development, it was a stage when most of human rights NGOs actually opposed the idea of adoption of new law. At the same time, the Council of Europe and numerous experts advised the government to introduce such a law, because with the increasing number of protests and increasing number of security concerns, it's very important to have some rules in place. So we tried to negotiate this issue with different NGOs who have by far more expertise in practical aspects of implementation and exercise of this right, trying to convince them that it should be consensus somehow found in the country. So the law is passed, and the law which is satisfactory both for the government and for civil society, whereas the rights of people and the need for safety and security would be balanced. We provided our feedback and our expert opinion back in 2011, I think it was the beginning of 2011, and faced criticism on the side of major human rights NGOs. But at the same time, since 2011, courts started to produce more and more decisions rejecting or limiting the right to protest, as there were too many claims submitted by Ministry of Interior and by Security Service, claiming that there is danger or there is possibility of violence. We know that the practice of European Court of Human Rights says that such claims by the government are not really the foundation for limitation of a right to process. And we also participated in numerous trainings for judges, encouraging them to examine the arguments presented by parties deeply and to issue decision wisely. But during last 2 years, the number of rejections or decisions which rejected the petitions to conduct the protest increased 5 times in the country. So human rights NGOs, at the end of the day, they still went to European Court of Human Rights, asking to analyze the situation and to see whether, of course, based on particular case, whether the right of person to hold a peaceful assembly was violated by such actions of the government. In April 2013, the decision of European Court of Human Rights was issued, and the rights of a particular person were recognized as violated or limited with because the government violated the principle of proportionality when used restrictions on right to a peaceful assembly, and the European Court of Human Rights actually recommended to pass appropriate legislation. I need to mention that yes, of course, it's important what is in legislation to ensure the right implementation of particular human right. The draft law prepared in 2010 and submitted to Venice Commission on Human Rights actually is quite European in terms that the Venice Commission on Human Rights said that this draft law may be adopted, and the Venice Commission doesn't really have too many concerns in regard to the scope of this law, but of course how this law will be implemented on practice and what administrative practices will be involved matters a lot. So we really hope that now Ukraine will adopt this legislation. We are really glad to see that there is some consensus between NGOs and government in regard to these issues, and we understand that further work is needed to actually monitor how the law will be implemented and whether the implementation practice and following administrative practices will correspond to European standards in this regard. So this is our first case study. I think I mentioned all of this. The second case study is the right to fair trial. During the last 3 years, we've been asked to comment on different aspects of the right to fair trial covered by European Convention on Human Rights, Article 6, and especially Ukrainian society had a lot of concern dealing with criminal justice, as criminal justice reform has not been implemented, but has been under discussion since early 90s. So finally we can say that even WFD was not directly involved in the reform itself, but the organizations which were involved in our work, they supported the idea of criminal justice reform a lot. And last year, the criminal procedure code was passed, and Ukraine was actually positively received a lot of positive comments in regard to a new criminal procedure code from Europeans. In this regard, it's very important to mention now that there are numerous cases which deal with particular issues. For example, Ukraine been heavily criticized at the same time for numerous politically motivated cases or cases which were defined as selective justice. One of such cases is Lutsenko case. As our leader of the panel already mentioned, the handbook for human rights, for parliaments and on human rights is our Bible, and this Bible was partially translated and adopted for Ukrainian needs twice. And I had the pleasure to do so in Ukraine. And we, in the first version of this handbook, was more focused on rights of people with disabilities and minority rights. As in the second edition of this handbook, we introduced the case of Lutsenko. And it's interesting because what happened in Ukraine, Lutsenko case, you all heard, this is the former Ministry of Interior who was imprisoned. And in August 2012, the European Court of Human Rights issued the decision. Actually, there are two aspects of this case. There is Article 5 dealing with pretrial detention, and also Article 6 and 18, where the court actually said that prosecution aimed on other issues, or the goal of prosecution was not to investigate criminal case, but it was some political motivation behind this case. And interesting thing is that until like January 2013, nobody actually translated this decision in Ukraine. When we started to prepare our second edition of handbook, we recognized that there is no translation of this decision, and there is a lot of speculation around this issue, and there is a lot of unclarity in regard to the scope of this issue. So we were really lucky to first to publish this handbook, to have possibility to present it at the Parliament, and thanks to this very nice cooperation between Westminster Foundation and the Parliament and visit of George to Ukraine, we had a meeting of the Human Rights Committee where the Ombudswoman was present, and finally number of people at least opened this book and read the part of the decision dealing with Lutsenko case. And we make claims that also, like European Council of Europe and European Court and numerous organizations were talking about this in general terms, but it probably was the first time when people opened the book and read what is in the decision. We can only say that in 5 minutes, the advisor to the president showed up at our meeting of the Human Rights Commission and said, okay, I just had a talk with the president and he promised that he'll do something. And in 10 days, Lutsenko was free. So the president issued the pardon to this person. Because, and our message was clear that the international community actually already gave the final opinion on this case. And there is no debate anymore at the international level whether it is violation of criminal justice or it is not, whether it is violation of Article 5 and Article 6, and whether Article 18 is involved. So we think that our work really influenced the situation, and the presence of international experts on human rights issues really adds a lot to effectiveness of delivery of this opinion. As somebody mentioned yesterday, it's very important who the person is who delivers the opinion inside the parliament, because if you have somebody who is highly respected and people listen to this person, then the effect may take place much quicker than if you have huge international forums but nobody really listens to them. So I think this was really the case. This case also showed that there is still lack of understanding of a whole scope of Article 6, because many of human rights people now say that actually the system of pardon itself is partially contradictory to the idea of fair trial and under the Article 6, because if the trial took place and decision was made by the court, then how come the president could just issue the pardon in few days without actually review of this case and without proper review of this case? And it opens an entire new stage for the reform and for public discussion in Ukraine, and I think it's starting, and we hope that it will continue, hopefully with the participation of WFD as well. The second case, which I wanted, the third case actually, is language bill. Language bill, why? As you see, Ukraine is a pink, big country at the border between Russia and Europe. And it's not enough that we are at the border, so half of the population in Ukraine speaks Ukrainian, half speaks Russian, but we also have 130 minorities and 79 languages spoken in our countries. And more than 1,000 people speak 43 languages. The rest languages are spoken by really small groups of people, which are really difficult to protect and take into account sometimes. Why we looked at this issue? Because we had a training for NGOs again. We had a training for civil society groups encouraging them to work with the parliament. And we had representatives of 5 language minorities which were really concerned with the new law on education, because new law on education actually denied them or their children right to study in own languages. It was a big concern for these minority groups, and we looked at this issue from point of view of European standards and trying to help them to negotiate this issue with the parliament and to ensure that their rights are protected somehow under the Ukrainian legislation. European Charter for Regional and Minority Languages deals with this issue, and it entered into force for Ukraine on January 1st, 2006. In 2011, Ukraine went under the evaluation process for the second time, and this was a hot issue in 2012 when we had parliamentary elections. So basically, most of the parties recognize that this is an important issue, and they need to talk about it. But nobody knew for sure, like, how to deal with this issue. There are too many groups, too many minorities. So, and finally, some money were allocated to help the protection of the culture and languages of national minorities. What's important for us is that the Charter itself has very broad definition of regional and minority language. So basically, it's up to the state to negotiate this issue with the groups living within the territory of the state and to decide which groups are such that could be recognized as regional and minority, and their languages might receive the special protection, and which groups are not such under the definition of the European Charter. So, as a result, the law passed by the parliament gave the status of regional and minority languages to 20 languages. And as you can see, these are very different languages. Like Russian was recognized regional language in Ukraine, compared to Ruthenian or Karaite or Krimchatsk language. And these languages are spoken maybe by 1,005 or by 1,006 people. Thank you. These are really minority languages. And of course, experts have different opinions about this law, because the level of protection needed for some of these languages from point of view of being in danger is very different. And many claim that Russian doesn't need protection in Ukraine at all, that Russian is actually a threat to our state language, to Ukrainian language. But at the same time, this law provided opportunity for all these groups to develop and to have a right to access to budget and to request the state to provide additional protection. And this law made it clear that Russian is not official or state language once again. So we know that Ukrainian remains the state language of Ukraine. It's up to national, regional authorities or local authorities to give the status to one of the groups if the population, 10% of local population, speaks this language and requires such recognition. I will not go into all details related to implementation of this law. I can tell you that the tendency is interesting, because suddenly the small groups start to send requests to local authorities demanding recognition of their rights, which is positive sign, but also interesting thing is that not all of the 20 mentioned groups are active. And implementation of this law actually really depends a lot on the activity of these groups. As you can see, before 2012, we had different system of education. Now the education could be conducted in regional languages, if the language is recognized in particular region as such. we can claim that some involvement of VFD in this process really took place, because we participated in committee hearings as well, and after this training that we had with civil society organizations, and we submitted our proposals, and we can look at the Article 20 of the law, which says that needs of citizens should be satisfied, and now we see the link between two laws, law on education and law language bill, as we call law on languages, which gives the opportunity for those minorities whose languages are listed as regional or minority, and if they really want, if they are active and demand this recognition at the local level, they then have a right for their children to study in own language. So again, it all depends on the activity of particular minority or particular group. And there were a lot of discussion around this legislation in Ukraine, but we believe that this law on one side provides equal opportunity and ensures non-discrimination of different groups. At the same time, it keeps a balance and peace in the society. Again, it depends a lot on a position of the representatives. I only want to finish my presentation by summarizing some results of work of WFD in Ukraine. We strongly believe that our efforts added to more transparency to legislative process in Ukraine. We see more and more requests coming from different committees, not just from Human Rights Committee, on human rights standards. So the concern now is broader within the MPs and the staff, whether different pieces of legislation actually are related to human rights and should go through expertise on human rights, related to human rights issues. I think we encouraged more trustworthy communication between staff of the parliament and civil society. They are more open to sit together and listen to each party arguments and discuss them. The human rights standards became the usual part of the legislative scrutiny, and we also, after the last year elections, especially, we see that the parliament becomes more open to use. We have a whole group of young MPs who are eager to accept new ideas, and we also have new wave of internship programs, including internship program for foreigners. We have first 2 American students doing internship with the parliament. One of them is doing internship with Human Rights Committee, and she actually just yesterday made presentation on the same-sex marriages and is doing more research. So we see more and more openness and readiness to discuss important issues at the parliament, and we hope this trend will continue. Thank you very much. This is what I wanted to say, and I'm open to the questions.
Thank you. We'll now have Pius.
Thank you. Good morning. I'm going to present on the establishment of a dedicated Human Rights Committee in Uganda. I'm glad to be here once again. I've come here quite often doing this work with the Westminster Consortium. And I think this is one of the programs, at least in Uganda, that has had very tangible and evident results within, moreover, a very short period of time. My colleagues yesterday mentioned most of the provisions of our law, so I'll not go into that. I'll just try to highlight what I think is specifically relevant to this presentation. The Constitution of Uganda has a very elaborate chapter on the protection and promotion of human rights, what we call or refer to as the Bill of Rights. And this goes through the whole Constitution, including the national objectives and directive principles of state policy, which really assists somebody in interpreting the provisions of the Constitution. As my colleagues again said, Parliament has a very, very wide mandate. Actually, when you read Article 79, apart from having the power to make law, there's a very interesting provision in the Constitution which says they have the mandate to promote the good governance in the country. And we have had a very liberal interpretation of that article, of that provision. I think they say the only thing that Parliament cannot do is to change one from a person, a man to a woman or a woman to a man. But it can pretty much do anything else. And so we took a liberal interpretation of that provision, and using Article 90 of the Constitution, that was able to inform us in the birthing of this committee. Perhaps a little background to this. Initially, and I'll talk about it a little bit more, we had a discussion we had a very good interaction with Angela Patrick, I think, at the very beginning of this process, where she interacted with the lawyers in Parliament. And after that meeting, I remember having a discussion with the Speaker, and we discussed what was the best approach to the human rights question, bring it to the forefront in the parliamentary work. One of the options we looked at, I remember, was to have a certificate of compliance with human rights issues. And we said that whenever a bill is brought to Parliament, the Attorney General should issue a certificate of compliance. That was our first option. And in that regard, I held discussions with Attorney General on that. But from the discussions we had, you could see he was very defensive, and he said, "You're telling us to do the obvious. By the time we bring a bill to Parliament, we have looked at human rights issues." So when I went back, it was clear at that point that we're not going to go very far with this. I mean, on the floor of Parliament, one would have easily said, "Why are you asking the Attorney General to do the obvious? After all, every bill they bring, it's their duty to make sure it complies with the Constitution." And remember, I talked about the Bill of Rights. So at that point, the Speaker said, "Let's go for the creation of a committee." And that is the process, the background, a bit of the background that is not in my presentation, I thought I would bring. And the interaction, the way this program was run, especially to do with the establishment of this committee, was, in my view, very critical to the establishment or to the success that we're now talking about. Because first was the interaction with the staff, the technical people. I'm sure if the people who work with Parliament here, they know the considerable influence that the staff of Parliament have in the running of parliamentary affairs. Because many times the politicians have an almost blind trust in the staff. So when there was that buy-in at that beginning, it became very, very easy after that. Now, before this committee, those issues to do with the human rights were being handled by the Committee on Legal and Parliamentary Affairs. But it was a very loaded committee, very, very loaded. As you can see, it had the function or to oversee the judiciary, Parliament itself, the Ministry of Justice, Constitutional Affairs, the Law Reform Commission, Electoral Commission, Human Rights Commission, and Inspectorate of Government. You can imagine, with all this huge mandate, it was no surprise that human rights issues really took the back seat. they were not prominent, they were not coming out prominently in the discussions, in the reports of Parliament. And certainly it led to an enormous backlog. I think at the creation of this committee, they had a backlog of about 8 reports which had not been scrutinized, because the Human Rights Commission, under the Constitution, prepares reports and presents them to Parliament, and these are taken to that committee. So I think by 2012, the committee had a backlog of about 8 or so years of reports. And you can imagine these are human rights issues. One would expect that human rights issues are usually urgent issues, issues that must be attended to immediately. Now, this also led to a recurrence of the recommendations in the subsequent reports. Because Parliament had not addressed them, the Human Rights Commission kept repeating the same or mostly similar recommendations because they were not being handled. So that was a very big problem. In 2009, May, there's something interesting about the month of May and this Human Rights Committee. May is when Westminster Consortium, really started. May, as you'll see later, is when this Human Rights Committee was created, and again, it's now May, I think, when we're talking about the success of the establishment of this committee. So, as I said earlier, we had the training, which was sponsored by the consortium. That's when we first met with Angela Patrick, I think, under the IBA. And it was very critical, I think, towards the approach that was taken in this program. So we had that training conducted. And then after we met with after we had an interaction with the staff, we then, I think through Jill, had an interaction with the members of that committee, of the Legal and Parliamentary Affairs Committee that had the mandate, because it was very critical for them to have a buy-in, especially the chairperson of that committee, in order to allow to release some of the authority he had, some of the powers. And I think that approach really assisted, because there was a buy-in. He was convinced. In one of the meetings we had here when we were coming up with a handbook, the consortium accepted for him to be part of the delegation, to come and see what really the issue of human rights was all about, and the creation of this committee. And he played a very, I think, active role in convincing the state that it was okay. As I will go further, I'll be talking more about that. So this training of the staff, training of especially that committee, in my view, went a long way in having a buy-in and owning this whole program for the creation of the committee. And the legal and legislative services, I think not all lawyers are necessarily specialists in human rights issues. So it was a very interesting interaction that we had, and it helps to remind, lawyers are reminded of the law they had studied on human rights matters, and that helped a lot in the establishment of this committee. Obviously, human rights issues, you cannot talk about them without talking about the state. I probably used a very strong word, being the aggressor, but the state is clothed with a lot of power that you need to always try to moderate that power. So the challenges especially was that convincing the government to establish in the background, they never came out very openly to say they had issues with this, but the Speaker of Parliament played, obviously, a very central role to the establishment of this committee. And also the chairperson of that committee on legal and parliamentary affairs in convincing his party, especially, and the government, that there was nothing to fear about this. It was going to promote good governance. In any case, it's already provided for in our constitution. Another challenge was already, as my colleague told you yesterday, we have quite a number of committees. And with these committees, you get financial implications. So one of the challenges that we thought we were going to meet was the issue of finances. We thought they would argue, or the argument would be made, that we already have too many committees. Since there's a committee already with that specific mandate, there's no need to create another committee. But I think one of the things that played in our favor was that this parliament, the 9th parliament, increased their numbers. There were more members. So administratively, you needed to have members fixed, placed in different committees. And the committees that were in place at that time were not enough to absorb them. So already we were going to create a committee. And this is where the Speaker of Parliament played a very critical role in the establishment of this committee. The other challenge was whether to have it as an accountability committee or an ordinary standing committee. Now, the importance of that is under the rules of procedure, all accountability committees are headed by the opposition, and the vice chairperson of those committees are also in the opposition. Well, I think this was the only issue in the establishment of this committee that was actively debated on the floor of Parliament. And in fact, this issue almost jettisoned the whole process of the committee because the government insisted that it shouldn't be an accountability committee for obvious reasons, because it would be headed by the opposition, it would be more robust in its reporting and that kind of thing, as we shall see in some of the remaining challenges to the operation of this committee. But I think after reflecting on it, it was agreed, the proponents of this committee thought this is not such a serious matter at this time to jettison the whole process. Let's accept for the party in government to chair this committee. And there's some advantages, I think, with that. Usually self-criticism is always better than being criticized from outside. So I think the speaker steered it, if you look at the answer, the debate, and said, okay, let's give it a try. Let's allow the party in government to chair this committee, and let's see how it goes. And so we were able to overcome this issue of whether there should be an accountability committee or not, but it's an ongoing, I think, discussion and debate. Probably the decision will be taken much later. So I've already talked about that, how we came up with the establishment of that committee. The Parliament then, the 9th Parliament, had to amend its rules to provide specifically for this committee, and on 21st May 2012, last year, it's only 1 year old, the committee was created in our rules of procedure as the Committee on Human Rights, as a standing committee. So under our rules, 147 stipulates the general functions of committees of Parliament. So the powers include, they discuss and make recommendations on bills laid before Parliament. The committee has the power to initiate any bill to do with human rights, which is pretty much everything. The committee has power to assess and evaluate activities of government and other bodies. They can carry out research, and they report to Parliament. That is the wider mandate. The committee, under the rules of procedure, has specific functions. One is to track and report on human rights concerns in every business handled by Parliament, monitor government compliance with human rights instruments, both national and international. They examine the recommendations. Now, these are the reports that you receive from the Human Rights Commission. and ensure that government is held accountable in this regard. And I think, as we speak, they have covered, in 1 year, the committee has been able to cover and clear the backlog of those reports that have been, that were lying in Parliament. And discussing the reports includes summoning the people who are responsible and making recommendations on those reports. Their reports are ready for debate or discussion in the House. They only were held back by the report of 2012, which is now out, and they are going to look at that, and then they'll make a comprehensive report to Parliament. And after that, I think we'll have gotten rid of the problem of the backlogs. Critically, the committee reports at least twice a year in Parliament, at least, but it can report many more times than that. So what has been achieved in the last 1 year, we, again, the consortium through WFD has supported an induction of the members and staff of this committee. We provided dedicated staff to this committee. We have a senior lawyer on that committee. I came with him. We have a very senior clerk, assistant to that committee. So the importance with which we have taken this committee has been very critical in its functions. It was important for this committee to see what others have done, and to that extent, they had an interaction, I think, with the UK, the Joint Committee on Human Rights, which was very informative. We came up with, the committee has come up with a very good checklist, human rights checklist. As we shall see later, this was informed again by the work that had been done under the consortium on the handbook for members of Parliament and staff. And what pretty much was done was to now localize that, pick out, and be more specific. So that was also another tangible achievement, I think, of this program. So we have that checklist. Achievements, human rights reports, as I've said, have been handled or are being handled. There's now a very close linkage between the Human Rights Commission and the committee and Parliament, which was previously not really that close. But not only the Human Rights Commission, with other human rights CSOs, very, very close. They have regular meetings. Issues can now be raised very quickly and given the prominence and discussed in the House. And I think this was also important in the approach to this program because we had the CSOs on board right from the beginning. We created, personal linkages with these people. And so whenever they have an issue, it's very easy for them. They know who to call. We have had interactions, and it is easy to have these matters addressed as quickly as possible. And it's important. One of the achievements, I think, has been the discussion. We have an ongoing spirited discussion of the Public Order Management Bill. And because of, one, the training that was given to the staff and the training of the members of Parliament, when you look at the level of debate, if you look at the report, which I participated in preparing, the report with my colleague Solomon on the bill for discussion by Parliament, it's been now, I think, almost a year or more discussing that particular, as a result of the report that we prepared. You can imagine one clause now is debated for 5 days, 6 days. And these are 6-hour meetings or sittings of the House because now the members are better equipped to raise these issues, okay? To raise these issues and discuss them. And I think it is something really to look back at and feel very proud of what has been achieved. Of course, the marriage and divorce bill in Uganda, I think the level of debate now has gone a little bit higher. People are more critical, the members of Parliament, and they look at these issues in a better way. Even the journalists, for example, who are part of this program, they are better able to report and pick out those human rights issues. So the tools, there's the handbook I've talked about that was prepared in a very, I think also in a very interesting manner, that it was not just handed to the different parliaments. I think we all participated in the production of this book. So the approach really has been very participatory, and there's a lot of buy-in and ownership. You take it as your own. And I think that was very important in the success of this. We also use the Interparliamentary Union. They have a checklist, Office of the United Nations Commissioner for Human Rights. We have the checklist that we have I've talked about that was prepared with support from the British High Commission in Kampala. I've talked about building the synergies with the different human rights actors in the country. And of course, the staff who are very critical to the operation and the success of this. So the challenges, obviously, you can imagine, party loyalty. The chairperson of this committee is a member of the party in government and the vice chairperson as well. Interestingly, maybe another mention, one of the hiccups that we almost had with the creation of this committee was that we had a group of MPs who wanted the committee to be called Equality and Gender, Rights. People with disabilities made a lot of input in this. So one of the thing, we worked very closely with the proponent of this, and I think it was the visit that was arranged by the Westminster Consortium. I think when we went to Mozambique, we had a very close interaction with this member of parliament, and we agreed that we'd talk to the speaker and the party so that the member representing persons with disabilities would be the vice chairperson of this committee. And that helped. Then they dropped and said, okay, our issues will be discussed in this committee. So that kind of behind the scenes worked a lot. Party loyalty, currently the committee has, I think, 26 members. And the party in government on that committee is represented 53%. And then 40% are those, rather 47% in the opposition. Now that is very important because when you look at the general representation of the party in government in parliament, they have an overwhelming majority. I think it's over 75%, close to 80. But this committee, you can see the balance. They came down from that close to 80 representation in the House to 53%, which I think is something important. But I think they are moving very slowly in as far as this party loyalty thing is concerned. And I think that's one of the main challenges for this committee. Then the attitude of members outside this committee. When you look at the mandate, it's wide and most likely touches on the powers of other committees. So the members are always skeptical. Is this a super committee? Is it our supervisor? So you have to keep on, massaging them and trying to find a way of getting them to accept the need for this committee. So that is still work in progress, especially as far as the mandate. Must they look at each and every bill, or do they pick and choose those bills that are glaringly having issues of human rights? So that is one of the challenges that is still continuing. The tenure of members is very short for all standing committees. I think it's 2.5 years. So at the end of 2.5 years, we may have a different membership. That comes again with a whole retraining of the new members of the committee. So that is, in that way, it's a challenge. I talked about the ongoing discussion, but I think with time, the committee, inevitably the majority in parliament of the party in power will come down naturally. It's a natural phenomenon. And I think as that happens, I'm certain this will end up being an accountability committee. I have no doubt in my mind with time. Then, of course, my colleagues and others have talked about the educational backgrounds of the members. Sometimes it's not very easy. Human rights issues are not very obvious, but you do that. And then, of course, the ongoing capacity of the staff, because also the staff sometimes are rotated to different committees. But I think the approach was to train the entire staff on human rights issues, and that will sort out the problem. So what remains? Obviously, there's something to do with the post-legislative scrutiny. I'm now talking generally about the program, whether it will survive or not, but that would be a discussion for another day, especially that the program is ending. Developing a human rights manual for the members, still looking at the funding for this function, and designing elaborate programs, to strengthen the capacity of the support and the members. Lessons learned: specialized dedicated subject committees are essential in holding government to account. I think it's very important. When you're establishing this, you have to think about the leadership of the committee. It's very critical, it's important, whether it should be a party in the opposition or the party in government. Building synergies is very critical and important, and fostering political will among all stakeholders is equally important. So, in conclusion, we are very, very delighted with this progress made so far, and as far as this committee is concerned, and we're very grateful to the consortium for this. I don't think, when I look back, that it would have been this plain sailing for the establishment of this committee, especially if we had not had those preparatory, preparing the ground, the interactions we had. It was very important. Of course, the challenge would have wanted, if the program had extended, to have some test cases to see this committee really coming out with reports and how they go about them. But so far, so good. We have some funding of the committee, so as far as the sustainability of the program or the committee is concerned, it's being funded like any other committee, which is, I think, a very good thing. So we thank you very, very much for that. Thank you.
Thank you, Pius. And now I'd ask Angela to talk to us about particularly the TWC tools.
I'm very grateful to everybody for their kind, very, very kind words about the work that we did with TWC in each of the partner countries. And I'm pretty inspired by the stories that we're hearing from Oksana and from Pius about the ongoing work that our partners are taking forward, both within the parliamentary staff and in terms of our NGO partners on the ground in each of the partner countries, continuing to work not only with other donors, but with WFD to try and build on this work, to better empower parliaments and individual parliamentarians to work directly on human rights issues which are of importance in each of the countries participating in the programme. I should say a little bit in introduction about why I'm here. Philip was very kind in terms of giving a little bit of introduction to my own personal history. I see some of my former colleagues from the House of Commons sitting here, so I think I probably need to give a little bit more of an explanation about why you have the Director of Human Rights Policy from a UK NGO sitting here telling you how things are done in Parliament. I was invited to become involved with the TWC programme as part of the House of Commons commitment to their work with the wider TWC agenda. I worked with the Joint Committee on Human Rights, that's the UK's Parliament's Human Rights Committee, for almost 6 years as one of its legal advisors. And we were approached by the International Bar Association because it was one of the first human rights programmes they had undertaken which had engaged directly with Parliament. And it was really timely for the TWC and the IBA to start looking at Parliament's responsibility and how parliamentarians engage with domestic and international human rights responsibilities. Both internationally and regionally, dialogue on human rights had begun to increasingly focus on responsibilities connected with making rights real. How do we do this? How do we ensure that we better respect everybody's human rights rather than seeing them as distant constitutional dry texts that we maybe all rely on when we're in trouble or somehow otherwise dragged within our justice system? How do we make sure that these international instruments that our diplomats go to negotiate in exotic countries around the world and then bring home and forget about, how do we make sure that they're actually relevant to people? And quite a lot of these international organisations and regional organisations were starting to focus on the fact that all of the institutions of state, be they judges, government, or parliamentarians, have a responsibility to implement those basic standards in a way which avoids human rights violations, which avoids breaches of fundamental rights, like the right to fair trial, like the right to protest. And the real reason behind this is if all of the institutions of government recognise that responsibility up front, it means that the breaches themselves might never happen. Not only is that better for individuals, but it's better for governments because it makes it cheaper in the long run and better for good government to ensure that each of the institutions and bodies of government are pointing in the right direction and saying that these are the standards which lie at the heart of who we are as a nation and that we each take responsibility in our own way for making them relevant and real and accessible. And for parliamentarians, that was really easy because in making rights real, parliamentarians play a really special role because as legislators, they can act as a first defence by ensuring that laws that are passed in a way which respect domestic constitutional standards and reflect international obligations. As the scrutineers of government action, they are the first line in telling government where law, policy and practice has gone wrong. If they're effective, parliamentarians speak loudly and they speak for the people. So as representatives of individuals, they can raise clear patterns of human rights abuse which are arising in practice and which are affecting their constituents directly. And by controlling the budget, which is a much bigger question, parliamentarians have a particular power to try to promote good government in those areas which require a dedicated examination of how scarce national resources are being divided. So, for example, they have a responsibility to examine education and health and other programming to understand whether or not the right to education, the right to health, the right to an adequate standard of living is being considered in the programmes of government and the long-term goals identified in each annual budget. So a little bit about the background, but I'm very glad that I'm here this morning because I've looked at the other programming and it's been really helpful to me to be involved in the TWC work and to see how CSOs and parliaments work together, whether they work together or not, as we discovered in some of our partner countries. The relationships are different around the world and in some countries non-existent. So with my new hat on as the Director of Human Rights arm of one of our UK CSOs, I must admit that I'm very glad that I've not had much of an opportunity to become homesick for my former workplace I have been invited quite regularly to come back to Parliament and to talk to committees and to give evidence to committee inquiries. So I'm glad that it's not been empty exercise in sharing my experience of being a parliamentary employee and saying around the world we have a constructive relationship with UK CSOs that flows two ways from Parliament through to NGO experience and back again, albeit there's an arm's length relationship where NGOs in the UK are encouraged to act as a critical friend, and one where having an approach which is neutral and all-party and apolitical is much more valuable than one where you are partisan and where you fail to provide evidence to support your case for change. It's something that I hope we'll see spreading through other countries, through our partners' work with NGOs in other countries. But I've been asked really to cover by George a little bit about how we worked in this part of the programme and what seemed to us to be successful. And I think we've already covered some of the areas that I was hoping to pick up in Oksana and Pius's presentation. But really, I'm a little worried to hear the handbook referred to as the Bible. The handbook really began as the training materials for this part of the TWC programming. And there are a lot of materials already out there available for parliamentarians to use. For example, in 2005, Pius already mentioned, the Interparliamentary Union worked with the UN to produce a handbook for parliamentarians. That's currently being updated. And that's an exceptionally useful resource, but it tends to focus on the substantive areas of law. So it talks about the UN human rights instruments, and it talks about individual rights like the right to life, like the right to health, the right to education. And what I'd been told the TWC programme was intended to do was to share experiences and talk about tools which individual parliaments could use to make those substantive standards important for parliamentarians in their work. So, in fact, we were encouraged in our training materials not simply to regurgitate the law, because most of the training partners shared the same international obligations, but to look instead behind that and to ask, what tools do parliamentarians need? What tools have they already got? And what are the shared challenges that they face in trying to raise concerns about these substantive legal issues in their daily work? So that was the goal of the handbook, and it was based around the shared vision of the TWC training as it was presented to me, which was that each of the partner countries in the programming were there to share experiences. We were there to recognise that although across each of the parliaments involved in the programmes, there were varied practices, procedures, and structures within their own parliaments, that there were certain shared issues that would come up time and time again from which we could share and learn from each other. And a good starting point for this was the fact that the Joint Committee on Human Rights itself in the United Kingdom is very new. At Westminster, we have a very old parliament, but a very new Human Rights Committee. The Joint Committee on Human Rights in the UK was only established in 2001, and so it only existed for around a decade at the start of the training. We were learning in the UK how best that committee could work, and many of the challenges which Pius has identified around the establishment of a Human Rights Committee had already been faced by our Joint Committee on Human Rights, our JCHR. So we were hoping, as part of this process, to share with others, those who had human rights committees or different structures, our experiences of the challenges our members had faced, and some of the issues that we tried to introduce in order to make their work more effective. The handbook itself, we decided to produce as a foundation for each of our partners to take forward and to build upon to ensure that they had some materials to work with their own staff to develop their future working. It was designed not as a Bible, but as a basic introduction to some of the human rights principles that could be applied by parliamentarians and should be applied by parliamentarians in their work worldwide. It was meant to be a practical tool and based, as I say, on shared challenges and experiences. So we used our local partners to integrate case studies from each of the partners into the handbook structure. So case studies, checklists, suggested questions for parliamentarians. These were all the hooks around which the handbook were built. Designed, in fact, not as a Bible, but as a framework for further research, analysis, and development of new tools and techniques designed to fit the work of individual parliaments. This wasn't intended as a Bible. It was intended to inspire. And that's why we're really grateful to hear from people like Pius, who are taking the work forward, whether with WFD or with other donors, to develop tools which are designed for their own parliaments, to fit for them. And I know my colleague, Murray Hunt, who is the legal advisor at the Joint Committee on Human Rights, has recently been to Lebanon, where they've produced an Arabic version of the handbook, designed to start thinking in the Middle East and the Middle Eastern parliaments around how human rights tools could be developed to ensure that parliaments there integrate both domestic constitutional standards and international standards into their work. But the one thing that the handbook does look at are key areas where each parliament has an opportunity to influence debate on human rights standards both at home and overseas. And I'll outline a few of these because they may come up in questions. And they're reflected in some of the case studies that we've seen presented by Oksana and Pius. The first is human rights treaties. We all, as partners in the TWC project, share the bulk of our international obligations and being signatories to the major UN human rights treaties. So there are a number of opportunities for parliamentary committees or MPs, be they dedicated human rights, we've called them defenders in the human rights book, or individuals or committees working on wider issues, to look at treaties. First, should a government ratify a treaty? If they've ratified it, are there any reservations? Are those reservations appropriate? Should they be removed? In the long run, ratifying a treaty doesn't mean just signing a document. It means making sure that those obligations are respected in practice. And that's where parliamentarians can have a really important role. They can examine whether existing law, policy and practice needs to change to ensure that everybody within society benefits from those agreed international minimum standards. And it's often parliamentarians who are best placed to understand whether those rights are made real in practice or not. The second issue we looked at was national implementation, so continuing that notion of reflecting on national law, policy and practice. Through the scrutiny of budgets, legislation and other instruments, parliamentarians are really well placed to examine whether governments are getting it right first time or whether they're really relying on the courts, if the courts function well, to ensure that rights are respected. The third is looking at the national infrastructure for the protection of human rights. We've already talked about, both in Ukraine and Uganda, the importance of Parliament plugging into the bigger infrastructure which exists, be it the National Human Rights Institution, created under the Paris Principles to ensure that there's a central focus point for the implementation of human rights standards domestically, or whether it's other bodies who have direct responsibilities for making rights real, the police, the prisons, ombudsman, if there is one, looking at if you have a children's commissioner, are they working well? The courts themselves, are they effective? Are they able to provide a remedy? Is their independence protected? And fourthly, working with civil society to increase public awareness of human rights. I now work obviously for a CSO, but even within Parliament, being able to use the knowledge that's accrued within specialist organisations outside Parliament and to work with individuals who have hands-on experience was invaluable. It ensured that members had a direct line into information and resources which were expensive and difficult to accrue, and if that knowledge was there, it was wrong to ignore it. And international working, of course, reflected in the TWC work, but also being able to go back to international institutions and bodies to say, we've worked on these issues in our parliaments. They really are challenging, but here's a way forward. We worked in Uganda, for example, with West African Congress, was it? We had a meeting where we looked at other parliaments regionally and said, how do we all work together to share best practice, to talk about where we've got problems that we're all facing, whether there are easy routes out, and whether there are experiences that we can all share to ensure that we get it right and we get it right better. We focus principally in our training on work with committees, probably because it was easier to work directly with parliamentary staff and MPs who were already working on issues which raised human rights problems. But the handbook itself acknowledges that parliaments and parliamentarians working on human rights issues goes well beyond human rights committees. The power of an individual member to ask questions, to table private members' legislation, to work in all-party parliamentary groups or caucuses, all contribute to the valuable role that parliaments can play in highlighting domestic, constitutional, and important international human rights concerns. Through our work, and I'm sure this is all reflected in some of the speeches you've heard yesterday and again today, we identified shared challenges, and they're highlighted in the third chapter of the handbook. What role should parliamentary committees play? Parliamentary committees, as we've heard from Pius, come in many different formats, and they have different powers which they can use for different purposes. And a lot of their functions and their power will be determined according to their structures, their resources, their membership, whether they have an active chairman, an inactive chairman, whether they have staffing that means that they have access to the advice they need. And that goes much further than a human rights issue. That's about democracy and the functioning of effective parliamentary structures. And the other parts of the WFD programme have been looking to support clerks, lawyers, speakers in ensuring that there's a process of reflection to ensure that parliamentary scrutiny is as effective as it can be. We've obviously looked at individual members, but some of the issues around human rights that we particularly identified was the need for committees and individual parliamentarians working on human rights issues to have access to independent, high-quality legal advice. Now, I'm a lawyer who used to work with Parliament, and they paid my salary for 6 years, so I probably would say that, wouldn't I? But actually, having your own lawyer who knows the issues, who is independent from each of the parties involved in what are often highly political and contentious debates, is really important for increasing the confidence of parliamentarians, that they understand the issues and that they are able to ask informed, critical questions of government. Accessibility and transparency, both Oksana and Pius talked about this. If parliamentarians and parliaments who are working on human rights issues are transparent and accessible in the way that they do this, it encourages wider civil society and ordinary individuals to have confidence in the fact that these debates are at the heart of good government and that they can engage with individual parliamentarians to raise concerns when they think that their rights are being violated. Engagement with government, civil society and international organisations. I've talked a little bit about CSOs and international organisations, but what was really important at the Joint Committee on Human Rights was fostering a working, effective relationship with government and individual government departments to ensure that they provided enough information to Parliament to allow Parliament to scrutinise their work effectively. That doesn't mean that we were very close to government or that we had a symbiotic relationship in any way, but being able to have an arm's length discussion with government officials about parliamentarians' concerns was incredibly important, and it's something that staff across each of the partner countries were encouraged to consider. And the final one is the big question: how do we continue to increase the impact and effectiveness of these parliamentary committees? Obviously, Pius gave one reflection about his new committee and how in the future they might look at whether an opposition chairman might increase effectiveness. And similarly, in the Joint Committee on Human Rights, they've reflected on how their working methods could make them more effective. If they produce reports more speedily, would that mean that they were better for parliamentarians to use in debates? If they were shorter, would that mean people would read them? Because they used to be very long. Now they're shorter, and now they are couched in much more human language. Sometimes as lawyers we forget that we sound very boring. So the JCHR had to revisit its practice after around 5 years, shortened their reports and made them much more effective and much more user-friendly for ordinary parliamentarians. So that process of reflection is really important. And it asks the question, where next? And WFD has been really supportive of the work of my colleague Murray Hunt, who is the current legal advisor to the Joint Committee on Human Rights. And he has been working with an academic project here in the UK to reflect on the effectiveness of the Joint Committee, but also to promote a set of draft principles and guidelines for parliaments working on human rights issues. It's quite interesting because internationally, since 2001, we've had a set of guidelines for national human rights institutions. And last year, we got a nice set of UN guidelines on how parliaments should work with national human rights institutions. But we haven't got any international principles on where parliaments should start if they're looking at their own role on human rights issues. And what Murray suggested is that we should start an international dialogue about what those principles should look like. And he started suggesting some tools which look quite similar to those that are in the TWC handbook around the resources that need to be available to parliamentarians, the kind of relationships they need to build, and the type of respect that needs to flow between all three institutions of government, the government, Parliament and the courts, to ensure that human rights are effectively represented. And a copy of those draft guidelines are in your materials, and I'm sure he would appreciate, through George, any feedback you might have. Thanks.